several significant measures, and such as the new parliamentary committee established by C-22 and the ministerial directive inviting people to deal with mistreatment. And Bill C-59 is certainly a central aspect of our activities.
This bill has three core themes: enhancing accountability and transparency, correcting certain problematic elements in the former Bill C-51, and ensuring that our national security and intelligence agencies can keep pace with the evolving nature of security threats. C-59 is the product of the most inclusive and extensive consultations Canada has ever undertaken on the subject of national security. We received over 75,000 submissions from a variety of stakeholders and experts, as well as the general public. And of course, this committee itself made a very significant contribution, which I hope members will see reflected in the content of Bill C-59. All of that input guided our work and led to the legislation that's before us today. But we're only just getting started. When it comes to matters as fundamental as our safety and our rights, the process must be as open and thorough as it can possibly be. And that is why we chose to have this committee study the bill not after second reading, but before second reading. As you know, once a bill has passed second reading in the House, its scope is locked in. With our reversal of the usual order, you will have the chance to analyze Bill C-59 in detail at an earlier stage in the process, which is beginning now, and to propose amendments that might otherwise be deemed to be beyond the scope of the legislation. We have, however, already had several hours of debate, and I'd like to use the remainder of my time to address some of the points that were raised during that debate. To begin with, there were concerns raised about CSIS's threat reduction powers. I know there are some who would like to see these authorities eliminated entirely, and there are others who think they should be limitless. We have taken the approach, for those measures that require a judicial warrant, of enumerating what they are in a specific list. CSIS needs clear authorities, and Canadians need CSIS to have clear authorities without ambiguity so they can do their job of keeping us safe. This legislation provides that clarity. And greater clarity benefits CSIS officers themselves because it enables them to go about their difficult work with the full confidence that they are operating within the parameters of the law and the Constitution. Importantly, this bill will ensure that any measure CSIS takes is consistent with the Charter of Rights and Freedoms. C-51 implied the contrary, but CSIS has been very clear that they have not used that particular option in C-51, and Bill C-59 will end any ambiguity. Mr. Paul Hoos, during his remarks in the debate in the House, discussed the changes we're proposing to the definition of terrorist propaganda and the criminal offense of promoting terrorism. Now, there can be absolutely no doubt, I think this crosses all party lines, in our conviction that spreading the odious ideologies of terrorist organizations is behavior that cannot be tolerated. We know that terrorist groups use the internet and social media to reach and radicalize people and to further their vile and murderous ends. We must do everything we can to stop that. The problem with the way the law is written at the moment, as per Bill C-51, is that it is so broad and so vague, it is virtually unusable, and it hasn't been used. Bill C-59 proposes terminology that is clear and familiar in Canadian law. It would prohibit counseling another person to commit a terrorism offense. This does not require that a particular person be counseled to commit a particular offense. Simply encouraging others to engage in non-specific acts of terrorism will qualify and trigger that section of the criminal code. But because the law will be more clearly drafted, it will be easier to enforce. And perhaps we will actually see a prosecution under this new provision. There has been no prosecution of this particular offense as currently drafted. There were also questions raised during debate about whether the new accountability mechanisms will constitute too many hoops for security and intelligence agencies to jump through as they go about their work. The answer, in my view, is clearly no. When the bill was introduced, two of the country's leading national security experts, Craig Forsays and Kent Roach, said this, and I quote, "The bill represents solid gains measured from both a rule of law and civil liberties perspective at no credible cost to security." Accountability mechanisms for Canadian security and intelligence agencies have been insufficient for quite some time. Bill C-22 took one major step to remedy that weakness by creating the new National Security and Intelligence Committee of Parliamentarians. Bill C-59 will now add the new Comprehensive National Security and Intelligence Review Agency, which some people for shorthand refer to as a Super CERC, as well as the position of Intelligence Commissioner, which is another new innovation in Bill C-59. These steps have been broadly applauded. Some of the scrutiny that we are providing for in the new law will be after the fact, and where there is oversight in real time, we've included provisions to deal with exigent circumstances when expedience and speed are necessary. It is important to underscore that accountability is, of course, about ensuring that the rights and freedoms of Canadians are protected, but it is also about ensuring that our agencies are operating as effectively as they possibly can to keep Canadians safe. Both of these vital goals must be achieved simultaneously. Safety and rights together, not one or the other. Debate also included issues raised by the New Democratic Party about what is currently known as SCISA, the Security of Canada Information Sharing Act. There was a suggestion made that the act should be repealed entirely, but with respect, that would jeopardize the security of Canadians. If one government agency or department has genuine information about a security threat, they have to be able to disclose it to the appropriate partner agencies within government in order to deal with that threat. And you may recall that that has been the subject of a number of judicial inquiries in the history of our country over the last number of years. But that disclosure must be governed by clear rules, which is why Bill C-59 establishes the following three requirements. First, the information being disclosed must contribute to the recipient organization's national security responsibilities. Secondly, the disclosure must not affect any person's privacy more than is reasonably necessary. And thirdly, a statement must be provided to the recipient attesting to the information's accuracy. Furthermore, we make it clear that no new information collection powers are being created or implied, and records must be kept of what information is actually being shared. Mr. Chair, I see you're giving me well, a rude gesture, which could be misinterpreted in another context. There are a couple of more points, but I suspect they'll be raised during the course of the discussion, and I'm happy to try to answer questions with the full support of the officials that are with me this morning. Thank you.
Thank you. It's not as rude as it could have been, but thank you, Minister. Our first questioner is Ms. DeBruzen.
Thank you, Minister, for coming today. The security framework is something that is very important to my constituents, and as part of the consultations that took place, I had a meeting in my riding. Many people came out. It was well attended, and what came through were some very strong concerns about ensuring privacy rights and charter rights, and so that frames a bit of where I'm coming at with some of the questions that I'm asking today. The first one is actually, and you touched on it just briefly, but many people have come up to me and asked, why not simply repeal the former C-51 from the prior government and prior parliament? Why is any new legislation required? Why not just repeal it and leave it as it is?
The short answer to that, of course, is that C-51 as a single piece of legislation no longer exists. It is now embedded in a variety other pieces of law and legislation that affect 4 or 5 different statutes and a number of different agencies and operations of the Government of Canada. So it's a little bit now like trying to unscramble eggs rather than simply repealing what was there before. What we have done, based on the consultation that you've referred to, is meticulously go through the security laws of Canada, whether they were in C-51 or not, and ask ourselves this key question. Is this the best provision, the right provision, in the public interest of Canadians to achieve 2 objectives: to keep Canadians safe and to safeguard their rights and freedoms, and to accomplish those 2 objectives simultaneously? So we have honored what was our election commitment of dealing with 5 or 6 specific things in C-51 that we found particularly problematic. Each one of those has been dealt with as per our promise, but we have, in this legislation, covered a lot of other ground that came forward not during the election campaign, but as a part of our consultation.
Just for clarity, would you be able to list those 5 items?
Yes, I can certainly get the list from our platform. Making sure that civil protest was not in any way compromised, making sure that the Charter of Rights and Freedoms was paramount, particularly with respect to the threat reduction measures, making sure that there would be a review of the legislation after a certain period of time, and the legislation provides for a 5-year review when all the security framework of Canada will be re-examined, clarifying a number of definitions, like the one about terrorist propaganda that I referred to, and what was the other one? Make sure I've got them all. The no-fly corrections that we undertook to correct. So we also said we would create the Committee of Parliamentarians, which is done. We would create the Office for Dealing with Counter-Radicalization, which is done. So with the passage of Bill C-59, all of the specific elements that we referred to in the platform will be accomplished.
All right, thank you. So the other piece that's come up more recently, and we've heard as a question that's been raised in Parliament, is the breadth of this legislation, because it is quite a read. And so perhaps can you help us to understand how all the new legislative changes are linked? Why is it important to make all of these changes at the same time in one piece of legislation?
Because they do come together as a comprehensive, coherent package. And again, that is a product of the consultation. Never before has a government gone out to Canadians to say, have your say about national security. Tell us what works, tell us what doesn't work, raise the issues that you want to raise. We had a discussion paper that sort of stimulate the conversation, but there was nothing off limits for Canadians to raise. And the things that they raised, some more strenuously than others, some in larger volume than others, but the issues that were raised are the issues that are included in Bill C-59, and they are all interconnected. To give you one example, some people have said, what about the CSE provisions here? Is that directly relevant? Well, CSE was one of our campaign commitments. CSE is a topic that was raised during the consultation, And the new innovation, one of the new innovations that we're bringing in the legislation, is the creation of the Intelligence Commissioner. And the Intelligence Commissioner deals with CSE issues, with CSIS issues, and with other issues. So it makes sense to do them all together as a package. And there are a great many cross-cutting issues like that that lead one to conclude that you need to debate this package as a comprehensive package rather than in bits and pieces where the continuity would not be obvious.
I only have 1 minute, so perhaps this becomes a very short answer. But another issue that's come up is CBSA oversight, which is a question that comes up in my community. People ask about it. There isn't any independent oversight under our current regime. Is there, under the Bill C-59 regime, CBSA oversight?
Yes, insofar as CBSA deals with national security and intelligence matters, it is covered by Bill C-59, just as is CSIS or CSE or the RCMP or any other security, intelligence, or police organization at the federal level. Their activities in relation to national security and intelligence are covered by C-59 and the new National Security and Intelligence Review Agency. What's still missing with respect to CBSA is an individual complaints mechanism for officer conduct unrelated to national security. And we will be bringing forward a proposal to deal with that specific. That is one gap that remains in the architecture, and it will be subject to separate legislation.
Thank you.
Ms. DeBruzen, Mr. Motz.
Thank you, Mr. Chair, and thank you, Minister Goodale, for being here this morning and your team. I want to just, I guess, compliment you and the ministry on bringing this to committee before second reading. I suppose I'm naive in my newness about the intent behind that, and I hope to understand that better, appreciating the fact that it will give us as a committee an opportunity to look at the bill in its entirety without being locked into the scope, as you had mentioned before. Mm-hmm. One of the things that I find encouraging is that the bill does look at a number of factors that were, I guess, not considered fully in C-51, and this is a complement to that, which is very, very good. Obviously, when you have decided to bring this back to committee before second reading, it makes me feel as if there is something that you recognize as a ministry that we can make better, that we can maybe do some tweaks to that hadn't been done when this was first drafted. Is there anything that comes to mind that you would ask us as a committee to pay particular attention to that hasn't already been dealt with?
We listened very carefully, Mr. Mott, to the public reaction and the parliamentary reaction when we tabled the bill in June. By and large, it was favorable, but with a piece of legislation that's this large, there will be differing perspectives and points of view. And over the course of the summer, there's been some elaboration on that. Some academic papers have been written, and various people who were involved in the consultation have come back to raise a question about this or a concern about that. But there are two areas that I would mention in particular. One is the provisions around SCISA, the Security of Canada Information Act. And whether those provisions can be improved or upgraded. Some of the experts, for example, like Professors Forces and Roach, have made some suggestions in that regard that we're prepared to take a very careful look at. Because that is a critical mechanism here for agencies to be able to share information, but to do so on the proper legal basis properly protecting privacy. And the Privacy Commissioner made some observations as well. So that's one area. Another is you may have noticed that earlier in the fall, I issued new ministerial directives to the security agencies about how they deal with information sharing with foreign entities. People have noted that a ministerial directive by custom has the force of law. But it may be valuable to take that concept and actually find a way to put it in legislation, so that there's a legislative anchor or hook for the ministerial directives. Okay. So those are just two possibilities that we could consider, and I hope by the end of this conversation you will agree that your optimism was not misplaced.
Well, we'll see. I remain optimistic. One of the things that did strike a comment from across many people who are into this and study this is that the appreciation that, the protection of national security and the whole idea of national security is a nonpartisan team sport. Mm-hmm. And we all need to be on the same page with how it plays out. What's also unique about C-59 is that it's more prescriptive than what our allies have. And it's like we have a lot of the regulations that could be regulations inside this bill. And you had mentioned before, sir, that one of the things that you wanted to see is the ability to ensure national security kept nimble, that they were able to keep pace with changing threats. And I'm wondering if everything is prescribed in a bill and we only have a 5-year review cycle, we all know that sometimes bills take a long time to change. Would we be in a better spot to take some of the good things we see in 59 and move them into the regulation scheme, so that if we have to change things, if we have to be nimble to changing threats, that we can make those adjustments in a more readily, efficient fashion?
I would be interested to look at any specific suggestion that you might have to make in that regard, where something is better done by regulation than actually in legislation. That's completely possible because we're doing the legislation in the way we're doing it, having this discussion in committee before second reading. So if there's a suggestion or an idea about that that you'd like to bring forward, we'll take a look at it. It is actually, your comment is the opposite of what we usually hear, which is put it in the bill. Don't leave it to regulation. Put it in the bill. So I think it would depend on the specific proposal.
Well, the only reason I say that is because the face of terrorism is changing. And sometimes we get locked into things from a bill perspective, and they're not easily adjusted. And that's all I'm getting at.
Yeah, I would point out that there are a number of places where approval procedures are put in place where we have made arrangements for emergency situations and exigent circumstances so that the necessary approvals can be obtained, but that doesn't stand in the way of agencies taking the action they need to take in an emergency.
Just one very brief comment. Very brief, thank you. You indicated that C-59 was an attempt to clear up some ambiguity in language. And in just some of our preliminary conversations as a committee, we've already identified some that cause us, remain to cause some ambiguity still on and how the language may have been used, and so we definitely want to make sure that we're consistent in that, and we may be proposing some adjustments to like sharing as opposed to disclosing, reasonable probable grounds as opposed to is likely to, those sort of things, and we want to be consistent on how we apply it.
I'll have to invite an answer at some other occasion. Mr. Dubé, 7 minutes, please.
Yes, thank you, Chair. Minister, thank you for being here. I just want to point out a couple of things, perhaps, for the record before we get going. There's a lot of it has been made about our ability to study the bill more thoroughly by doing this before second reading, but at the end of the day, we still only get you for 1 hour on a 138-page bill. So certainly I want to express some disappointment on that. At the end of the day, beyond the question of scope of amendments, it doesn't necessarily allow us more space to study what is, as you can see from the size of our binder, is quite an extensive bill. The other thing I wanted to mention is in terms of this notion of unscrambling eggs. Certainly I have no doubt in the ability of the Justice Department to do what my colleague Randall Garrison did in his bill C-303 that's on the order paper right now, which repeals in its entirety all the provisions that were brought in by former Bill C-51. So I think the notion that it is unfeasible would be, I would argue, incorrect, because we have been able to develop such a bill. Those things being said, I do, of course, have questions. And the first one I want to get to is in the changes to CSE in Part 3 of the bill, in Section 24(1) specifically, where we talk about this acquiring, using, analyzing, retaining, or disclosing publicly available information. Now, that section specifically mentions, despite subsections 23(1) and 2, which are the subsections that are specifically protecting those actions from being done to Canadians and in Canada. Therefore, obviously means that any of this data being acquired this way can be done to Canadians and in Canada, would be my understanding. And I just want to understand here, because certainly the argument can be made, well, it's publicly available information, so that's too bad for people who maybe don't manage their social media very well. But there's a few things that are of concern, specifically language like disclosing that information. Who's that? Sir, sure.
Refer once again to the exact section you're looking at.
So in Part 3,
Yep.
24(1).
24(1). Okay, thank you.
And then it goes on in A and B. So A is acquiring the information. B talks about infrastructure information for the purpose of research and development, testing, and so on. And then testing or evaluating products, software, and systems, including testing or evaluating them for vulnerabilities. Is there not a concern that we can get a web of inference here, and despite the publicly available nature of this, that we can start going through someone's social media information that might be public and creating profiles of people who might not necessarily be national security threats and having this data stored? That's my first question. The second one is, what is meant by disclosing? Who exactly is that information being disclosed to?
Mr. Dubé, could I ask Greta to start?
Certainly.
The chief of the Canadian Security Establishment, or Communications Security Establishment.
Thank you very much, Minister, and thank you for the question. With respect to this section, Section 24(1), that does talk about CSE may acquire and use and analyze publicly available information. I think two things perhaps to first frame this conversation is, number one, is that it has to be in relation to our mandate. And we are a foreign signals intelligence organization. We focus on foreign targets and foreign threats to Canada. So we don't have a mandate to focus on Canadians. We're definitely an organization that's focused on foreign threats to Canada. In terms of the intent of this provision, it very much is allow us to be able to conduct, I would say, perhaps sort of basic research with respect to our mandate. And I give you an example. For example, we might issue a foreign intelligence report or a cybersecurity report. And there might be publicly available information that would help complement that. For example, if we were talking about a security breach or a cybersecurity breach that happened, we might want to reference publicly available information that may talk about the nature of that breach, how it was reported elsewhere. So it's very much not, we don't have an investigative mandate. We don't have a mandate to focus on Canadians. Again, it's very much in association with our mandate, foreign signals intelligence and cybersecurity protection.
So fair enough, but so if we look at 23(1), it specifically mentions that the activities done by the Centre must not be directed at a Canadian or any person in Canada. But Section 24 says, despite subsections 23(1) and 2, the establishment may carry out, and goes on to what we've already read. So essentially we're saying that normally it wouldn't be against Canadians or any person in Canada, but now that's no longer the case because it's specifically saying despite subsection 23. And certainly I understand the hypotheticals that are being offered, but does that section not allow for the retention and use of technology that can create these large webs that'll inevitably catch people in Canada when we think of, Stingray technology, things like that it can be used? Is that not going to be a potential, because the way the section is drafted certainly could when we're looking at acquiring, using, analyzing, retaining, or disclosing infrastructure information for the purpose of research and development, for the purpose of testing systems or conducting cybersecurity and information assurance activities on the infrastructure from which the information was acquired. To me, that seems to create a situation where you could be collecting information from infrastructure here in Canada, which obviously Canadians are using, without necessarily the same accountability that's created by omitting Canadians in Section 23.
Well, maybe I might just add two additional points. I would refer to, on Section 24.1, in the actual first text there, it talks about in following activities in the furtherance of its mandate. And again, our mandate is foreign signals intelligence and cybersecurity protection. So that really is the overarching piece that would be associated with the rest of the subsections. And also, just in terms of ensuring appropriate use, all of CSE's activities, including anything would happen under 24.1, would be addressed and covered under the review mechanisms that the Minister already spoke about. So in terms of the National Security Intelligence Review Agency, and of course the new National Security Intelligence Committee of Parliamentarians.
So thank you. My time is fleeing, and I think that just shows how an hour with the Minister is perhaps not sufficient, considering that I've just spent nearly 7 minutes on one section of the bill.
But an hour with Greta is more useful.
Certainly. Minister, I want to go back to the information sharing section, and I just want to understand, because this is what you said in the House, is there's a difference between the language that's now there of disclosure versus the language that was there of sharing. And I want to understand what legal grounds that has to create any sort of difference.
We wanted, in the presentation of this section, we wanted to make it clear that no new power of collection is being created here. This is all in reference to information that already exists.
So, Minister, if I may, just in that context, hypothetical.
I'm sorry, Mr. Dubé. I was giving you a bit of a run there as it is. Mr. Picard, 7 minutes, please.
Merci, Monsieur le Ministre.
Thank you, Minister. Ladies and gentlemen, thank you for being available this morning.
Put my Molière verb. J'aimerais poser.
I'd like to ask questions with respect to CSIS and the decision, the Noel decision. There was an issue of disinformation and the type of information that be retained, and the way that we resolved this issue. As the Justice said, we couldn't keep the information, even if the information could be useful to the investigators.
Judgment is very interesting. Obviously, he was concerned about certain procedures and practices, and he laid out his instruction as to how those practices were to be adjusted. C-59 captures Justice Noel's advice and judgment for a procedure going forward, dealing with the management of data and data sets, and that is all articulated in a very elaborate set of rules that will apply. But Justice Noel also said this. I don't have the exact quote in front of me, but he said, bear in mind the CSIS Act was written in 1984. And think back to 1984. If you had a cell phone, it was as big as a bread box. The fax machine was cutting-edge technology. A lot has changed. And as you mentioned, Mr. Picard, he said explicitly, maybe all of this needs to be revisited in the light of all the technological change that has taken place since 1984. There have been recommendations from the Security and Intelligence Review Committee. There have been judgments of the courts. There have been findings by judicial inquiries into a whole variety of circumstances in terms of the collection, the analysis, and the utilization of certain data sets, what should be permitted, what shouldn't be permitted. We've taken all of that on board, and it is now embodied in the rules laid out in C-59. There was another dimension, too, of Justice Noel's judgment, where he was suggesting, in some pretty blunt language, that there needed to be greater communication and candor between the agency and the court. And David, David Vigneault, the director of CSIS, yes, could I just ask him to comment on that issue with respect to candor?
Parfait. Merci, Monsieur le Ministre.
Thank you, Minister. Mr. Picard, I can give you an idea about the way we are interpreting Justice Noel's decision. Yesterday, at the service, we have a list of issues that's raised with the court when we're going to be appearing before them for warrants. So the court can raise issues. So we take all of these issues into consideration. We return to the court to explain in detail. We provide technical briefings to explain the situation. This is what led us to this Noel decision in 2016. There is a level of transparency and a partnership. Perhaps that's not the right word to use, but we do understand the obligations that are put on CSIS, and we work very closely with them to try to respond to their concerns. I had an opportunity to meet with federal court justices and other members of the judiciary to give them my vision of the way that the service would conduct itself in the future. I think the level of trust has been reestablished to a great extent, and this obligation is something that I have on my shoulders, and we will continue this work. When speaking of transparency, that's good, but does this also provide you with greater flexibility? So this flexibility will allow you to get good information, better information, but what about information that involves third parties? What does it bring? What does this legislation bring to you? The way that we work is that all information or intel that the service uses when we're collecting data has to be linked to our mandate, which is to investigate threats to the security of Canada. Bill C-59 defines the categories of information determined by the department. We're going to be able to say, here are the categories of information. You have the right to use this. At that point, my organization and my officials will, in an organized manner, go out and collect this information. This is what we call a Canadian data set. At that point, the commissioner, the intelligence commissioner, will assess the department's evaluation and will be able to use this information and the federal court will become involved in determining whether we are able to retain this information. Then the way that we use this information will be reviewed by the new intelligence review agency and by the parliamentary committee. So if we look at the way that the categories have been established by the department, the way that we're going to be using this information, and the way that the federal court and the new agency will get involved, and the fact that this will all be reviewed by another committee, that enables us to use the data that's absolutely essential to evaluate threats. As Justice Noel said, the Act has to be in keeping with the times, and that will enable us to work on threats in a proper way in 2017, but we will have accountability to protect third parties.
Thank you, Chair, and thank you, panel, for being here. I have a few questions. One of them, with all due respect, Minister, C-51 was passed a few years ago, and I think that it did receive widespread support in the House, including, I believe, you voted in favor of it. And I think that it did make some changes that at the time were appropriate. And now in review, 3 years later, we're looking at essentially a review. This is not a total rewrite, I think you would agree, of the original bill, but it does add some ingredients that probably are important. And certainly one of the small things, but when you mention about the law expressly prohibiting protest and advocacy and so on, would the changes in the new bill have resulted in charges that were not allowed for in C-51? Like, have we enhanced the probabilities of prosecution in 59 over 51?
That's always difficult to predict, Mr. McKenzie, as you know. But in the example I used in my remarks, I think my answer to your question would be yes. In the tools that are available to deal with terrorist propaganda. The problem with the language in C-51 was it was very broad, and in the language of lawyers in court, it was so broad it was vague and unenforceable. There was some, if you recall, discussion right during the election campaign in 2015 that the language in that particular section might have been used to actually capture certain election campaign ads, which obviously wasn't the intention of the legislation. So we've made it more precise without affecting its efficacy, and I think made it more likely that charges can be laid and successfully prosecuted, because we have paralleled an existing legal structure which courts and lawyers and prosecutors are familiar with, and that is the offense of counseling. But clearly, it doesn't have to be a specific individual counseling another specific individual to do a specific thing. If they are generally advising people to go out and commit terror, that's an offense of counseling under the way we've written the Act.
And I think that I hope that we would all agree that that's an appropriate change. And I think we do see changes in here that we agree with, and I think that for good reason, you've got a 5-year review. I'm not sure if we need to go 5 years. Maybe some of these things need to be reviewed more often than 5 years. I look at many of these things that we talk about, and when we talk about the collecting of information, for the people on the street that are enforcing these things and trying to keep Canadians safe, I would question why we get so involved in worrying about information we may collect from the public domain, such as social media. And I know that I think Canadians would know that from the national media, we have been the beneficiaries of information obtained in other countries from social media where people were active. And I would use the example of the incident that occurred in southwestern Ontario, where the information came from another country, of information they had obtained through social media. And it would just seem to me that we are only fooling ourselves if we think we shouldn't be watching social media in our country for the benefit of Canadians particularly.
Mr. McKenzie, on that point, I might ask Kevin Brosseau to comment. I think you're referring to the driver case at Strathroy. The information, that critical piece of information that came to us from the FBI was actually an intelligence operation they were conducting. It wasn't via social media. It was another method that they were using. But your point about the ability of them to share with us and us to share with them was absolutely crucial. The relationship between CSIS and their counterparts, the RCMP and their counterparts, is extraordinary. And in that particular case, in the space of about 8 hours, they were able to identify very precisely what was going on and stop a very significant tragedy from happening.
Mr. Spiegelman.
Mr. Chair, I'd like to welcome Minister Goodale to the committee with his team and extend my congratulations to Mr. Rigby and welcome him in his new role. I'd like to also echo Mr. Matz's appreciation for bringing this bill to us before second reading. Minister Goodale, my question falls squarely into the overarching framework that we need both good security and protect our charter rights. And it's about Canadian youth and their vulnerability to terrorism. In particular, we have terrorist networks around the world like Abu Sayyaf in the Philippines, Al-Shabaab in Somalia, ISIS in Syria and Levant, and future terrorist networks potentially or likely that will prey on youth in various countries. Children, really, people, according to my reading, who range between age 14 and 19 or into the early 20s. Section 159 of the bill brings the Youth Criminal Justice Act into connection with C-59, applies it to C-59, including the principle that detention is not a substitute for social measures, and also that preventative detention, as provided for in Section 83.3 of the Criminal Code, falls into that same framework, that it's not a substitute. Wonder if you could comment on your vision for how the bill relates to young offenders, youth, vulnerable youth, essentially also pre-commission of any terrorist offenses or recruitment by networks, and then also your broader vision about how we can do better in terms of preventing terrorism in the first place by making sure that these networks do not prey on Canadian youth and children.
It's a very serious issue, Mr. Spangeman. And you really have touched on the two elements that we're working on. One, through the collection of new provisions that are here in Bill C-59, we will give CSIS and the RCMP and our other agencies the ability and the tools to be as well informed as humanly possible about these activities and to be able to function with clarity within the law, within the Constitution, to do what they need to do to counter those threats. And specifically where offenses arise in relation to young people, the Criminal Youth Justice Act applies, so that is the process by which young offenders will be managed under this law. The other side of it is prevention, and all of the countries in the G20 and probably many others around the world are turning their attention more and more to this question. I know it's been discussed among the Five Eyes allies. It's been discussed among the G7 countries as well as G20. How can we find the ways and share our expertise internationally among all countries that share this concern? How can we find the ways to identify vulnerable people early enough that you have a decent opportunity to intervene in that spiral downward of terrorist influence, intervene effectively to get them out of that pattern. Obviously, intervention and counter radicalization techniques will not work in every circumstance. That's why you need a broad range of tools to deal with terrorist threats. But where prevention is possible, we need to develop the expertise to actually do it. And that is the reason why we created the new Canada Centre for Community Engagement and Prevention of Violence, so that we would have a national office that could coordinate the activities that are going along at the local and municipal and academic levels across the country, coordinate all of that, put some more resources behind that, make sure that we're sharing the very best ideas and information so that if we can prevent a tragedy, we've actually got the tools to do it.
Mr. Thank you. Very briefly, would it be fair to say that disrupting recruitment efforts of international or domestic terrorist organizations is as significant as disrupting terrorist finance?
Yes. Yep. It's all important. It's hard to put them in an order of hierarchy, but it's all important activity.
Thank you.
And it has to be a coordinated, full effort with everybody on board.
Thank you, Mr. Spengler. Ms. Gallant, 5 minutes.
Thank you, Mr. Chairman, and through you to the Minister. Canadians from coast to coast, they are concerned that the government, they're asking why the government appears to be more concerned about the rights of terrorists than the safety and security of Canadians with the returning ISIL fighters. So do you believe that the returning ISIL fighters can be rehabilitated?
I think, Madam Gallant, in the way that you put that, it's a complete misstatement of the government's position. We believe we need a robust set of measures to deal with the terrorist threat. That includes our participation in the global coalition against Daesh. And Canada's role there, especially our intelligence collecting capacity, has been a very large asset. We need the surveillance, the intelligence gathering, the monitoring capacity of our security agencies. We need the ability of our police forces to collect evidence, to prepare cases that can be sustained in court. We need the ability to use no-fly lists, the ability to list people and entities under the criminal code, to apply for peace bonds, to use the threat reduction powers of CSIS. You need
Mr.
all of those things together, including a prevention effort.
Okay, and I do recall from Defense that your government withdrew the CF-18 fighters that were cover for our soldiers and fighting ISIL as well. Why does this bill lack the legislation that includes measures to criminalize travel to regions under the control of terrorist organizations?
It's already an offense under the criminal code.
To go into the regions?
If you are traveling for a terrorist purpose, if you leave Canada to travel for a terrorist purpose, that is an offense under the criminal code.
So why are the people returning not being charged under that offense?
Well, there are about 60 of those returnees back in Canada, and bear in mind these are people who have gone to a whole variety of theaters around the world. Theaters of terrorist activity around the world. Some would have been directly involved, others less so. The security and intelligence efforts of Canadians and all of our allies around the world are watching these people intently to know exactly what they're up to. But when they come back, and if evidence is available that can stand up in court, they are charged. We, in the last 2 years, there have been 2 charges that have been laid because we believe we have the evidence that can be prosecuted in court. Up until that time, no charges have been laid.
Okay, but Minister, you say the number 60 when in reality we don't have a finite figure. In fact, with the mass migration of people seeking asylum across the U.S.-Canadian border, those are the people who wanted to be caught, and the border enforcement agencies have been overwhelmed with those. What about the people who crossed into Canada who didn't want to be seen? We don't know that there are only 60 people who were fighting ISIL. Now, in light of the recent terrorist attack domestically that Mr. McKenzie referred to, there are terrorist attacks in the UK, EU, in addition to Canada, which included the acquisition and use of objects available to citizens, and vehicles, chemicals, etc. Has the government reviewed the provisions of C-59 to ensure that it permits appropriate emergency disruptive activities, including without warrant where required?
We believe the measures that have been put together here, based upon the most extensive consultation with Canadians, experts, parliamentarians, and the general public, are indeed appropriate to accomplish 2 objectives. Number 1, keep Canadians safe. Number 2, safeguard their rights and freedoms,
okay,
and to do those things together.
One last question. Part of the de-radicalization center's job, or what they say one of their methods is to read poetry to the returning ISIL fighters. Can you specifically give us the title of a poem? Because we have people from other allied countries listening in that might help de-radicalize returning ISIL fighters.
You're obviously trying to...
Mr. Minister,
yes.
Unfortunately, Ms. Gallant has not provided you with sufficient time to provide your opinions on poetry. So I have 5 minutes left for Mr. Fragiskatos, and then we'll suspend.
Thank you very much, Chair, and thank you, Minister, and to the officials for being here today. Minister, at the outset, that you said that the Charter of Rights is paramount here. I wonder if you could speak to the place of the Charter in all of this, in Bill C-59, and where the Charter factors in.
The most prominent issue emerging from Bill C-51 was the original wording of what became Section 12.1 of the CSIS Act, which implied, by the way the section was structured, that CSIS could go to a court and get the authority of the court to violate the Charter. Now, every legal scholar that I've ever heard opine on this topic has said that is a legal nullity. An ordinary piece of legislation like the CSIS Act cannot override the Charter. The Charter is paramount, but the language in the way 12.1 was structured left the impression that you could go to the court and get authority to violate the Charter. In the language change that we have put into C-59, first of all, we have specified a list of disruption activities that CSIS may, with the proper court authorization, undertake. But when they go to the court to ask for authority, the ruling that you're asking from the court is not that it violates the Charter, but that it fits within the Charter, that in fact it is consistent with the Canadian Charter of Rights and Freedoms, including Clause 1 of the Charter. So that's the difference between the structure of the old section and how we've tried to make it clear that the Charter prevails.
Thank you very much. I wanted to ask about rights on the one hand, but I also want to ask about security on the other hand, but specifically a question about cybersecurity. We could have a situation as a result of even one attack where our banking system is undermined, where our electricity system is undermined. In what ways, and I've given you maybe 1 minute to answer this, but in what ways does Bill C-59 provide a more robust framework to prevent against such attacks and to protect Canadians?
You can expect to see from the government in the next number of months a whole range of proposals dealing with enhanced cybersecurity. The existing cyber policy goes back to 2010. It was thought at that time to be cutting edge, but technology has marched on. So we will be introducing an entirely new set of measures to strengthen Canada's cyber capacity. One piece of that is the new authority that we are giving to the CSE. And maybe I could ask Greta, in the interest of time here, to comment specifically on the cyber powers in the section on CSE.
Thank you very much, Mr. Goodale. So maybe I'll just highlight one in particular, given the reference to critical infrastructure, for example. So CSE currently deploys a number of very sophisticated tools to protect the Government of Canada systems. And with this legislation that's being proposed, one piece of it would allow CSE, upon request from a piece of infrastructure that's been designated as important to the Government of Canada, CSE, again, upon request of the infrastructure owner, could deploy our sophisticated tools to help defend a piece of critical infrastructure that's, for example, being attacked from outside of Canada. So that's sort of a concrete example of a particular measure that's included in here that would help Canadians and Canadian infrastructure be better protected from cyber attacks.
Thank you very much.
The real difference there is that without this authority, you have to sit back and wait to be attacked, even though you know it's going to happen. You're not in a position to be proactive. With the new authorities, CSE would be able to identify a very likely attack and be more proactive in preventing it from happening rather than trying to clean up the mess after it has happened.
Right. Looks like
30 seconds.
30 seconds. If I've understood you correctly, Minister, on the definition of terrorism propaganda, in C-51, it was so particular, it made it so restrictive. Is it fair to say that it was ineffective and relatively unusable?
Well,
is that a fair criticism?
It wasn't used in the 2 or 3 years between then and now. Our view was it is written in such broad language, it was largely unusable. So we've tried to use language that is more familiar in the history of our criminal law. The offense of counseling is very well understood, and using that language covers the problem, but does so in a way that's actually enforceable.
Skatos, and on behalf of the committee, Minister, I want to thank you, and you know that you're always welcome to come to this committee. With that, I think I will suspend. I'd ask just that in the interest of time and efficiency, for those who might wish to ask the Minister a question or two, that if they ask it outside the room so that we can continue on with officials. So with that, we'll suspend for 2 minutes. Now resumed for the second hour of these hearings. Since there's no presentation, I think we'll go directly to questions. I think Mr. Spengelman is leading off for 7 minutes, please.
Mr. Chair, thank you very much, and thank you for remaining with us for the second hour. My first set of questions is about the Secure Air Travel Act. Many colleagues, myself included, will have heard from constituents concerns about this, not the legislation, but the current circumstances under which particularly young people and children find themselves flagged by not being on, but flagged by a no-fly list. And it's difficult to get around it because we don't have a redress system. I wanted to ask you for your views, particularly in light of the minister's comments that this bill was introduced before second reading, for your views on the legislation as it stands in developing a redress system. Are there particular areas that we can pay attention to as a committee? We are being pushed hard also on the question of timeliness of having this this part of the legislation completed. Some constituents feel that there is room for a interim quick fix. I'd like to have your views on whether that's possible and feasible, but also once we have the legislation in place and the budget appropriation that's required to fix this problem, what would have to be done operationally to actually build this system? Because I think there's still some misperceptions just of the magnitude, the complexity that's involved in building an effective redress system.
Just as a matter of procedure, can I just ask colleagues we have quite an array of witnesses, if they could direct their questions to specific individuals.
Perhaps Mr. Rigby to lead off, but if there are other colleagues who want to come in, I'd welcome that as well.
Thank you.
Thank you very much, Mr. Chair, and thank you very much for the question. I'll pass it on to Monique, who's actually been working on this file to provide some of the details, but absolutely, I think the minister's made it clear that establishing a redress system is a priority for the government. I think within the legislation, we've already started down that track. In terms of a quick fix, I don't think that there's necessarily one that is readily available. As you say, over time, we are going to look at a more comprehensive solution in terms of redress. I think it's starting off with a centralized screening system so that the government actually does the screening. Right now, that is the responsibility of the airline, so we'll bring it back to the government so that we can actually provide more rigorous and consistent screening across the board. In the legislation itself, there are also references to the notion of an identification number that will allow those who request that identification number to be screened ahead of time, and if there's any misunderstanding with respect to being on the list, can be addressed before they actually show up at the airport. We've also made it clear that in cases where a child, for example, is not on the list, the government will actually inform the parents of that. And that is an important provision, we feel, in that there's a great deal of apprehension when there is a false positive match from parents that, okay, my child is my child on the list, whether it's through accident or through some other provision. I think it removes a lot of that apprehension if we can actually say to a parent, no, the child is not on the list. But over time, yeah, this is going to be a very comprehensive approach. I think that we will really have to, by having the centralized screening process, we are actually going to have to build the system up from the ground. So it will require a big IT fix, information technology fix, that will require significant funding over time to make that happen. But we feel that the legislation is definitely moving us in the right direction. Monique, did you want to add anything?
The only thing I'd add is that instituting a redress program is quite complex. It requires legislative amendments, regulatory work, consultations with airlines, and some fairly significant IT fixes. And I think in Bill C-59, what you have are really the essential first steps that lead us down the path of a centralized program. We have the proposed amendments here that will enable public safety to gather the information and to establish a program. So these are really the first steps that we need down the path to a redress program.
Is it your testimony then that you would not recommend any additional areas of examination within the bill, that the bill really captures what's needed to build the system?
I would say we're always open to creative suggestions. I think we always believe that we've thought of everything, but we welcome new suggestions down that, especially in terms of working with airlines and IT fixes.
I would absolutely concur with that. We're open to any suggestions, of course. Again, we do feel that is moving in the right direction, but we'd welcome any suggestions from the committee.
Are you able to comment how we ended up here? I mean, we have a lot of constituents who travel to the U.S. and they're saying, you know, as stigmatizing as it may be to have a redress number, that system seems to be working. Why are we in the current situation?
Can't really say why we're in the current situation. We are working with the U.S. We have established a Canada-U.S. redress working group to also facilitate the troubles that some air passengers may experience, and we are looking to the American experience in establishing their redress program and learning lessons from the way that they have done it.
Okay. I may ask you to venture outside of the box here, but would you have a rough estimate of how long it would take to build the IT parameters that you've described once we have budgetary approval and C-59 enacted?
Sorry. We are in very extensive consultations within government interdepartmentally on exactly this issue right now in terms of the actual dollar figure, how long it's going to take. I wouldn't be in a position right now to give you a firm estimate on either count.
Even a loose estimate would be premature?
It would be premature at this point.
And very briefly, in the remaining 20 seconds, how many departments and agencies would be involved in constructing this redress system?
There would be a number of other departments that we're working very closely with. Obviously, CBSA would be one of them, one of the agencies within our portfolio, Transport Canada, Shared Services. So those are only 3 or 4, but there are others as well that we will be consulting, Treasury Board, et cetera.
Thank you very much, both of you. Thank you.
Thank you, Mr. Chair, and thank you to the panel for being here today. Keeping in theme with costs, I'm just wondering if there's been an approximate cost on the budget to implement, and I guess that would be from the public safety officials.
Are you directing that to Mr. Rigby?
Please.
Okay. Mr. Rigby?
Are you talking about the entire bill right now?
Has there been any thought put into the approximate cost of full implementation of this bill?
Not in terms of the total cost, I don't think. I mean, certainly I could turn to my colleagues, but these are still early days. We'll want to have the legislation actually passed and become law. We certainly looked at some preliminary cost estimates in terms of specific measures, but I couldn't give you a grosso modo figure for the entire bill and its implementation at this point.
Those figures that you do have costs for, can you please provide those to the committee at your convenience, please?
I can certainly look at getting you some answers.
Thank
Absolutely,
you.
sir.
Specific to CSIS, Section 99 of the Act includes new language that prohibits CSIS from detaining an individual. Can you maybe help us understand the justification behind that reduction in power?
Actually, we do not have the power. We never had the power of detention. This is a power that is only reserved to the police. The way we deal with threats is essentially, we investigate, we collect intelligence, we inform our partners, and with the legislation previously that allowed us to have threat reduction, we can take some measures, but to reduce that threat. But those measures prohibit any detention. So we do not have, and we never had any power of detention.
Okay, thank you.
Thank you.
For justice and public safety, we had discussed at the committee the other day about changing terminologies, and can you just help us understand the necessity to change terminology in 83.3 of the code, criminal code, from is likely to prevent a terrorist activity to is necessary to prevent a terrorist activity, and how that change is anticipated to impact or affect our ability to make preventative arrests?
Mr. Brady?
I don't have the list. Of who from public safety or justice?
We'll go with Mr. Breaker.
Okay.
Thank you very much for the question. Yes, Bill C-59 would propose to revert one of the thresholds back to what it was before former Bill C-51. So there are two thresholds. One is the peace officer has reasonable grounds to believe that a terrorist activity may be carried out and reasonable grounds to suspect that the imposition of recognizance with conditions of the arrest of the person would be it currently reads likely to prevent the carrying out of the terrorist activity, but it's proposed to change that to be necessary to prevent the carrying out of the terrorist activity. So that would restore that particular branch of the test back to what it was originally and with the Anti-Terrorism Act of 2001. And that's attached to the branch of the test that's reasonable grounds to suspect. And it would require the police to present evidence of a greater link between the conditions to be imposed on the person or the arrest of the person and the prevention of terrorist activity.
So what we've done then is we've actually, in effect, made it more difficult to have an impact on national security by going back to even pre-C-51. Is that's what I'm hearing you say?
It is an increase in the threshold. This tool is available for use. It hasn't been used to date, but it may very well be used in imminent circumstances, in which case there may be a link between the necessity and the of using the tool to prevent the terrorist activity being carried out.
Okay, thank you. I do have to just comment that it is problematic to me that as our threat of national security increases, we would actually go backwards on our ability to protect ourselves from it. Again, maybe the same individual can respond to the change in changing the word, or the significance of changing the word from sharing to disclose. In discussing this previously, we were having some conversation of sharing information and what it means to disclose information, and whether that's just a cosmetic change in language, or do you see a substantive shift in how that can be carried out? Because as we know, the sharing of information is absolutely critical between departments, between agencies on national security, as well as our allied partners. But I'm talking in-house, in Canada, is absolutely critical. And do you see that as being any substantive change that's going to make it more difficult or easier to share information?
Perhaps I can tackle that one, Mr. Chairman, but I don't think it's just cosmetic. I think it's actually quite important. As the Minister had suggested, moving from sharing to disclosing, I think, is also making it clear this is not about collection. This is about disclosing information, and sometimes I think within the definition of sharing, it can be implicit that there's a collection dimension as well. So we wanted absolute clarity in that regard. Also, disclosing makes it very clear that it's from one body, one organization to another organization. And so there are certain requirements on the disclosing organization or agency now in terms of the information they give to another agency or organization. So absolutely, I hear you in terms of the sharing of information is extremely important. And indeed, I think that the amendments that are being suggested now within the Act are still aimed at, while protecting privacy and protecting rights, et cetera, to make sure that those organizations have the information they need to respond to threats. Did you want to add anything, Monique?
Thank you. Thank you.
Mr. Dubé, 7 minutes.
Oui, merci, Monsieur le Président.
Thank you, Mr. Chair. I'd like to go back to Mr. Rigby and Ms. Beauregard regarding the no-fly lists. Why is it so difficult to establish the cost for implementing the system? And secondly, if the bill is adopted and the legislative measures implemented and the money's not there, because the way you're speaking, I have the impression we do not have enough funds, does that mean that in the next parliamentary cycle that we'll have to wait for the next parliamentary cycle for the technical side to be implemented? Thank you very much for your question.
I wouldn't want to disclose the cost just because we're still having those discussions. So for me to provide an estimate right now, that would subsequently have to be revisited. I don't think that would be in anyone's best interest. As I said before, it's a very ambitious, highly technical fix in terms of the IT. And so we're having to cross a lot of T's, dot a lot of I's, work with a lot of other agencies and departments in terms of bringing that cost together. We do have an estimate right now. We put that with the government, and we are waiting for a response in that regard.
Merci.
Thank you. So you're waiting for a response from the Department of Finance for the budget, is that correct?
It's with the Department of Finance right now, with respect to the ultimate cost, yes.
Okay, merci.
Thank you. Mr. Vigneault, you talked about data sets that are not selected. So we're talking about a net that may include a lot of people. The minister with the new commissioner will essentially determine whether it's appropriate to collect and retain information. How do you distinguish between a data set that could be, for example, related to someone, and the minister thinks it would be appropriate to keep the data, but the commissioner doesn't? Perhaps he's had a conversation with a targeted suspect, and so the person doesn't really constitute a threat per se. He's more a victim of the other individual who does pose a threat. So a better way of asking the question, perhaps, would be, what do you do to distinguish between data sets that are not selected, that pertain to people who have nothing to do with a suspect, compared to the others? Thank you for your question. My answer is two-pronged. First of all, as I said earlier, there are a certain number of measures that exist that enable us to collect and use and keep data. So the minister determines the categories of data sets that we can use. This category is reviewed by the commissioner. This is a quasi-judicial process. If the data pertain to Canadians, well, at that point, it's the federal court that's going to have to determine whether it's strictly necessary to conserve and use the data, but the federal court will look at privacy protection and determine whether we can use the data. So the system that will be implemented with C-59 establishes these criteria, enabling us to use the data. The second part of the answer, I do understand that there's a great deal of interest in the way we use data, but for intelligence organizations such as ours, it's essential that we have this data. I'll give you a tangible example. Having data, a data set, will enable us to use, will enable us to characterize the threat. We'll know who these threats are in contact with. We can determine whether they constituted a threat. And if we determine that that's not the case, this data set will ensure that innocent people are not going to be affected. When you collect information, civil society has concerns that the data may gather up or collect all kinds of information that's not really pertinent to your work. So that, in that context, this could carry over to this class of non-selected data. So from the technical side, what do you do here? Because I know it's the court that will determine whether or not you can use the data, but how do you distinguish between the non-selected data and people who are not threats? The way I understand, which perhaps may not be as in-depth as yours, but it's vital that we cast a broad net when we're trying to collect data. Yes, the way we're going to work is that if the bill is adopted, the non-selected data will be set aside, and only those designated people will have access to it. So we'll gather information and compare it to the data that's related to the threat, and this data will be segregated, and the designated people will be the ones who will be able to do queries. Every time that this is done, the activities will be reviewed to ensure that our procedures, our implementation procedures, meet with the spirit of the law. And with respect to this broad data set, how do you distinguish what information is relevant and what is not? Do you you say you set the information aside? All that's well and good, but how do you decide which information is pertinent? We begin our investigation based on the actual threat, not on the data set. So if we've identified a target who's involved in terrorism or spying activities, if we see that this individual is in contact with other people, we have information such as telephone numbers that can be useful to us, and then so based on that, people are concerned that we're going to do fishing expeditions, that we're going to use this non-selected data in order to do some fishing. But we use this non-selected data so that the people being investigated really do constitute a threat, because what often happens is the data enables us to determine that they're not a risk.
Expedition question. Ms. Damoff, 7 minutes, please.
Thank you very much, and thank you for being with us for our second hour. I actually want to go back to the no-fly list or passenger protect program. I too have met with the no-fly list kids, and I have a young man who's in my riding, and I've been working with his mom since almost after I got elected on the fact that his name is shared on the list. I just want to go through a little bit that's in the bill and some that isn't. You mentioned the U.S. has a redress system, and that's what we're moving towards. My understanding is the reason that it's more difficult and more costly for us to create one today than it would have been if it had just been done at the beginning or even several years ago. So the fact that this list has been out there for so long, to now take it and create it now is actually more difficult and more costly than it would have been if we had done it the way the U.S. had done and done it much earlier. Is that correct?
I think in retrospect, certainly would have liked to have the redress system in place at the outset, but to create the fix now is certainly more challenging, without a doubt. I can't speak with authority that it is going to be more expensive, but I suspect that might well be the case, but I'd have to confirm that.
That's fine. One of the questions, and I actually, when I read the legislation, it's still not 100% clear to me, so if you could clear it up, is who creates the list and who maintains the list? Is it the airlines or is it the government?
This is where I am going to turn to Monique, because she is very central to the whole process.
Fine.
But I will say one thing. I mean, the list has been maintained effectively by the airlines up to this point. And so one of the key changes in the legislation is that we go to a centralized, or the screening has been done by the airlines. So the screening will now move back to the government, and we will do the screening, not the airlines. And there are a number of advantages to that. But I'll let Monique, who again is in the trenches on this, go through the process for you.
So with respect to the actual Secure Air Travel Act list, it is the government that creates that list based on basically a dual threshold of identifying individuals who are suspected of posing a threat to airlines, but also individuals who are suspected of traveling abroad to participate in terrorist activities. So that is the basis for creating the list. That's not to say that airlines don't have their own list, but they're not terrorism related. The airlines will have their own lists based on people who've had rage fits in airlines and things like that. So if somebody happened to be perhaps snowboarded by an airline that has there's quite a complex process in place when somebody is flagged at registration, that there may be an instance where they could be on the SADA list, there's a whole process going back to the government, to Transport Canada, and to Public Safety to vet whether or not that person is a close name match or an actual person on the list.
So, thank you for that. And that's one of the things that the legislation will change or two things actually. One is that parents can or guardians can now contact the government to find out if in fact their child is a match on the list, correct?
Exactly, yes.
That is correct.
And the other change is to do with people who have applied to have their names removed from the list. Can you go through the change that we made for that?
That is the recourse process where essentially, and that was a mandate of the Liberal government when they came into power to make changes to the recourse process. Essentially, there was a deemed decision previously that if after 90 days the minister had not rendered a decision, the individual would remain on the list. We have now reversed the process to where the minister has not provided a response within 120 days, then the person is automatically removed from the list. So the recourse process has now been made, I guess, more fair.
And that was a change that this committee recommended as well when we did our study on the national security framework. And we maintain a Canadian list. Other countries maintain their own lists. Is that correct?
That's correct.
So we're not using a U.S. list in Canada? That's a question I'm often asked.
No, again, as I explained, we have our own list, and the list that is shared with airlines, as Vincent indicated, is the Canadian list.
Thank you. There seems to be confusion certainly amongst the parents, that there's this list somewhere that every country has access to. So, and in terms of a short-term fix, I just want to get this on the record because my colleague, Mr. Spiegelman, brought it up. As crazy as it sounds, I've been told that if people apply for a loyalty number from an airline, it actually acts in a similar way to a redress number to allow them to fly more easily with the airlines. Certainly, my constituent, that's what she was told, and I actually went back to Public Safety because I thought it was crazy, but when it was explained to me that it provides a unique identifier, can you just confirm that that actually does assist for passengers who are flying?
Yes, it does. Some of the unique identifiers are based on date of birth, the sex of the individual, etc. So by using an Aeroplan number, for example, there's an automatic deconfliction in the system confirming certain identifiers. So using an Aeroplan number actually would help, or a WestJet number would actually help those who have close name matches.
Okay, thank you. And with this legislation, this will now allow you to put the regulations you mentioned in place to be able, like the step would be the legislation, the regulations, and then funding to be able to put it in place. Is that how, will this allow you to start to put some of the other pieces in place?
It certainly starts us down that track, it does. But funding will be critical.
Right. Okay, thank you.
Emma, before I turn it over to Ms. Gallant, most of you, the witnesses here, are frequent appearances, frequent flyers, shall we say. Some are not. For those who wish to reflect on whatever it is they said or read something in Hansard that requires clarification, you're more than welcome to write to the clerk for any clarification you wish. Ms. Gallant. 5 minutes, please.
Thank you, Mr. Chairman. Under Section 30 and 31, can you explain the necessity, and this is for our Chief of CSE, including the Minister of Foreign Affairs in the decision-making when authorizing cyber operations? So why is it necessary to include the Minister of Foreign Affairs in this decision-making process?
Thank you for the question. I believe, Ms. Gallant, you're referring to the cyber operations that are in the proposed bill. And there's two different types of cyber operations that are in the bill. First are called defensive cyber operations. And for that, the Minister of Foreign Affairs would need to inform the Minister of Foreign Affairs of this initiative. She wouldn't actually be approving it, but she would be informed of it. For an active cyber operation, not a defensive one, but an active cyber operation, the Minister of Foreign Affairs, as you said, would actually also have to be approving it, a sort of a two-key approval, if I could say that. And I think the important thing to underline here is that these operations, whether they be defensive or active cyber operations, are focused on foreign targets, are focused on outside of Canada. So if you think of the Minister of Foreign Affairs, of course, having an interest in and responsibility for Canada's international affairs and foreign affairs, because these activities would be implicating foreign targets, foreign threats to Canada, that would be part of the rationale for that.
Okay, so just for the second part, the approval is required. Okay, for Mr. Rigby, what is the justification for C-59 changing the definition of terrorist propaganda in the criminal code, especially as it raises the evidentiary standard beyond what is the factual reality of current practices in radicalization, recruitment, and facilitation, and actually duplicates what is already the crime of counseling a criminal offense in Section 22 of the Criminal Code? And in light of this, will the government consider removing the proposed amendment in C-59 relating to terrorism propaganda?
I think I'll defer to my colleague from Justice on this issue, although the Minister, I think, did address a bit of your question with respect to the definition and the use of the word counseling in greater precision, but my colleague perhaps can provide a more fulsome answer.
Yes, indeed, there is a link to the counseling offense that's proposed in Bill C-59. The terrorist propaganda definition is proposed to be amended to mean any writing, sign, visible representation, or audio recording that counsels the commission of a terrorism offense. And so it's very closely linked to the new counseling offense. There were concerns with the wording that currently exists in the terrorist propaganda definition, which is advocates or promotes the commission of terrorism offenses in general, suggesting that that wasn't so easy to apply, and that has been deleted, and that's that fulfills a commitment that the government made to narrow overly broad definitions, including terrorist propaganda.
So that means that simple sharing, if somebody receives a message or sees something on social media, simply sharing that with another person for the quite possibly the purposes of information, that those people will not be prosecuted for simply sending or receiving this kind of information.
I think it's important to realize that the counseling offense, as proposed in Bill C-59, is an offense that would be subject to prosecution. Okay. The terrorist propaganda definition applies to a system within the criminal code which former Bill C-51 created 2 new warrants in the criminal code, one allowing for the seizure and forfeiture of terrorist propaganda in a tangible form, according to the definition, or a peace officer could come before a judge to seek a warrant for the deletion of terrorist propaganda from a website that's available to the public through a Canadian internet service provider. So we're looking here, terrorist propaganda definition applies to these warrants. Good. And it also applies under the Customs Act because it allows terrorist propaganda or prohibited goods under the Customs Act.
Mr. Rigby, also for you, the importance of securing cybersecurity with respect to our infrastructure is your purview, and it's very important to protect against cyber attacks. Now, we know that the grid, the electrical grid, is one source of exposure. So it's my understanding that all the provinces, including the United States for that matter, have a framework in place to protect their grids, with the exception of Ontario. Is there some federal provision or something that Parliament could do, even with C-59, requiring all the provinces and territories to ensure that protection is in place because we're all connected?
Regrettably, Mr. Rigby, there's no time to answer that question. Ms. DeBruzen.
Thank you. In the first round, I'd mentioned that one of the issues that was very important to people in my riding was the issue about charter protections. So I had a couple questions for the Department of Justice. I was reviewing your charter statement on Bill C-59. And the first question is, when was the last date that this was modified? Do you have just to make sure I have the last update on this?
The charter statement was tabled on the date that the bill was introduced, which is June 20th.
And there have been no updates as far as charter analysis?
No.
Can you...
At least no updates to the charter statement.
No. One of the things that came up quite a bit was the threat reduction measures. And I was wondering if perhaps you could outline what you found in your charter statement in respect to the threat reduction measures, please.
I think it's...
You can too?
I will provide some comments on that if the committee is comfortable. So essentially, first foremost, I think it's important to say that all of the activities of CSIS must comply with the charter. And I think the minister explained the way that the previous bill was Bill C-51, which became law, was constructed. There might have been an issue where you said that the way it was constructed. Bill C-59 essentially confirms that the law cannot create an opportunity to deviate from the charter. What it does in terms of threat reduction is that if ever we were to contemplate a threat reduction measure that would limit the freedom of someone protected by the charter, we would have to go to the federal court to apply for such an authorization. And then the federal court would determine if the limit on that freedom is reasonable and proportional, as the charter itself allows for. And so that is how the proposed Bill C-59 addresses the charter issue for the threat reduction mandate. Also, the law will specify the types of activities that are contemplated, so that will be transparent in the law. And the way I would then able to interpret that as the director of CSIS will be to determine if it limits the freedom of a people. I have to go for a test at the federal court, and if it's something that does not limit the freedom of people, it's an activity that I can do, and then the committee that supervises our activities, the new agency, would be informed, will be able to review that to make sure that we have complied with the act.
Thanks. I'm not sure exactly who the right person is to ask a question, but I think it's Department of Public Safety, Mr. Rigby. Has there been a gender analysis on this legislation?
Yes, there was.
And is that available?
Take that back and respond to that, but I believe it's a cabinet confidence, but
Okay.
I wasn't present at the creation, but we can certainly go back and look into that.
All right.
If it's not subject to confidence, I appreciate it if you'd forward it to the committee, please.
Thank you. And then the next piece is the Youth Criminal Justice Act, Part 8. I guess this would probably go to the Department of Justice as far as we're now creating a system whereby information about young offenders would be available to people issuing passports. Has that been, is that consistent with the objectives for the Youth Criminal Justice Act?
You may see under the provision, I believe it's Section 119 of the Act, there are a number of paragraphs dealing with authorities to share information under the Act. This is an additional paragraph to be added to that, which allows for the sharing of access to youth records for the purposes of administering the Canadian passport order, subject to the privacy protections of the Act. So it's consistent with the approach taken under the Act in respect of sharing of other information, and it's to it indicates to whom it should be shared and the reasons why, and it can be made available to the Minister of Public Safety, for example, in deciding whether to grant or revoke a passport. Because information relating to, for example, the fact that a a youth has been subject to a terrorism peace bond could be made available for consideration in making those decisions.
Thank you.
Mackenzie.
Thank you, Chair, and thank you, the panel, for being here. Now, I'm pleased that we're updating the existing 51, and I think there are some updates in here, and I'm sure we'll all agree in 3 or 5 years from now we'll be looking for more updates. But one of the things that has always been in my interest, and I think in Canadians' interest, is if we can disrupt and prevent things, it's always better to do that than it is to deal with the fallout afterwards. And I'm wondering if 59 has changed the scope of the non-warrant disruption activities designed to reduce threats been altered. And if so, how and why? And does C-59 require a CSIS officer to obtain a warrant to go and speak to a suspected person's parents about their child's radicalization or terrorist intent? And I recognize that when you go and do go to a court to get, or a judge to get it, there's a lot of work, a lot of time, and sometimes that time is of essence. And would this then enter into that whole process?
So thank you for your question. Specifically in terms of the non-warranted threat reduction measures, the new bill is not imposing any new measures. So the service has used the threat reduction measures about 30 or so times. And your specific example, where if we were to be aware of an individual, for example, who wanted to travel abroad for the purpose of joining a terrorist organization, we do not need a warrant to go and intervene with the parent or with people in the close proximity, close circle of this individual to inform them of what we know in order for them to maybe have an influence on that. So the Bill C-59 does not provide and make any changes to that provision. And we've used this, as I said, about 30 or so time, this measure.
And so would it be correct in saying that C-59 does not change with respect to some people being allowed to use disruptive practices with suspected terrorists?
So the way it changes the approach is if, as I was mentioning earlier, some of these measures were to limit the freedom of the individuals, then the service needs to apply for a warrant to the federal court. And there is a list in the bill that prescribes the type of activities we can do. But this can be done fairly quickly. We have the court is responsive to the urgency of threats to national security, but we have not had to use that provision yet. But the Bill C-59 clarifies the way it would be done, and that would be a tool. But one other thing that I would like to add to this is that when we use these tools, we must consult with partners, and specifically if it's related to terrorism, we would consult with the RCMP. The law makes it an obligation on our part.
Okay. And for the RCMP officers, the minister's already identified the situation I spoke of. Would there have been changes in C-59 that would have intervened in that whole process with the RCMP and the local police agency dealing with an outside agency?
I'll take the first stab at it and turn it to my colleague James to clarify or to correct things that I say that I'm wrong. I think it goes back to some of the minister's initial comments, Mr. Mackenzie, around the sharing of information, the nature of the sharing information being really the lifeblood of the effectiveness of responding to the terrorist threat and ensuring the safety and security of Canadians. We know that absolutely, and particularly amplified by what I would call the contraction between contemplation and action. We know that that period of time can be quite short, can be very, very short. So that need to be able to share that information is critical. And while the bill may not necessarily enhance that necessarily, it certainly solidifies the relationship that we have with partners, the existing relationship that we have through the National Security Joint Operations Center, where we work closely with our colleagues at CSIS and other departments to ensure that that information is shared on a timely basis, it's verified, the fidelity or veracity of that information is clearly understood, to ensure whatever tool tool is necessary to be used given the circumstances, recognizing that the facts are obviously, every incident will be fact-specific, that intervention can in fact happen in a timely way. James, can I turn over you to fix? Oh. So
You're
hopefully I'm
giving him
not wrong.
4 seconds in which to respond. Maybe at some other point you can work it back in. Mr. Fragiscatos, 5 minutes, please.
Thank you very much, Mr. Chair, and thank you again to the officials for being here today. Mr. Rigby, I want to ask you about a preventative approach. We heard the minister take a question on that, but I'd like to understand from the department's perspective further the public policy rationale, if you could go into that. Mr. Spengelman talked about the importance of a preventative approach. Indeed, a preventative approach could be more important than financing, dealing with the financing of terrorism. If you could get into that.
Well, I think, as the minister said, there are a range of options, and there are a range of tools that can be used. And so there are responsive actions, and he laid out what some of those were. And then there is a preventative side, which I think is just as important at the end of the day, and the minister, I think, made that quite clear. So he made a specific reference to the Canada Centre for Community Engagement and the Prevention of Violence. We're very, very excited about this new tool. It was just created back in June, but it affords us an opportunity for the centre to reach out at the grassroots level, at the community level, to work with Canadians, to work with Canadian groups, to do research on counter-radicalization, to reach out to youth, to try and nip radicalization in the bud, and to really try and have a holistic approach to to prevent radicalization before it starts. So it is already up and running, as I've suggested, as I've indicated. It has been. In addition to actually launching programming and launching grants and contributions, it's also been consulting with Canadians over the course of the fall with a view to actually providing a strategy for counting radicalization to violence that the government would like to present at some point. So it will be a very, very comprehensive approach, and I think, again, it'll be an important tool in what is already a pretty wide-ranging toolbox.
Thank you. I have a quote here from Philip Gursky, a security expert and former CSIS officer, who says, quote, "The previous government had an abysmal record when it came to countering violent extremism and early detection." To what extent have we learned from the cases of other states? Denmark, for example, has long put into place a preventative policy. There's around a dozen or so suspected former fighters who returned to Denmark who have been put into programming of the nature that we want to see here in Canada. To what extent have we learned from cases like Denmark and other situations?
We're in very close consultation with our allies and with others around the world. As the minister mentioned, whether it's in the G7, in the G20, working with other national security ministers within a Five Eyes context. The minister was recently in Italy as part of a G7 meeting of national security ministers. One of the topics that they focused on was extremist travelers and counting radicalization to violence. So definitely we're looking at lessons learned, exchanging best practices, and really across the spectrum, whether it's preventative or responsive, learning how we can work together and how we can strengthen those tools.
I cited the case of Denmark because they've had great success, as I think you know, in terms of there hasn't been, for example, a terrorist act perpetrated by a suspected former fighter. As a result, it is said by experts, in large part at least, due to the programming. Thank you very much. Ms. Bossenmeyer, I want to ask you a question about CSE's ability to prevent against cyber attacks. We've seen in other democracies, security agencies really come under threat, come under attack, where vital information is made public, and that undermines the security of the state. Could you go into that, please?
Sure. Thanks very much for the question. It's a key priority for the Communications Security Establishment to focus on cybersecurity. I've mentioned in a number of appearances recently that we've been in the business of protecting Canada's most sensitive information for over the last 70 years. And if anything, as you mentioned, that job has become more challenging and more complex given the nature of the threats that are out there, but also just the overall reliance by Canadians, by Canadian businesses, by the Canadian government for using information technology, and hence the importance of cybersecurity. So a great deal of our emphasis is around providing advice, guidance, and services, not only to the Government of Canada, but to broader systems of importance to the government to help them best protect their systems. A lot of emphasis in terms of protecting government systems, but as I said, also broader critical infrastructure. Some of the proposals that are in the legislation that's in front of this committee would allow us to further use our cyber capabilities to better protect Canadians' information. I mentioned one already in terms of being able to protect and deploy our systems on non-government systems upon request of a critical infrastructure owner, for example. The minister referenced another one where we'd be able to actually go out and try to prevent an attack against Canada or Canadians or Canadian infrastructure before it happens. So two examples of how this act would actually help us.
We're going to have to leave it there at two
better
examples.
Protect Canadians.
Yes, thank you.
Thank you, Chair.
Mr. Dubé, for the final 3 minutes, please.
Oui, merci. Et peut-être la fin.
Thank you. Perhaps the end of your answer is going to be relevant to the question I'm going to be asking. Part 24 that you alluded to earlier in this whole question of information on infrastructure and disclosure of information on infrastructure for the purposes of and I'll let my colleagues finish reading the bill. I'd like you to talk to the definition. The information on infrastructure, we're talking about physical, global infrastructure, events that occur with respect to providing information on a network. I just want to understand, based on the bill, what type of exercise will be done in future so that we can undertake such a study for the security of the network? And if I understand your mandate, you look at foreign threats, but unavoidably, you're going to do work associated with the Canadian network. Can you give me an example of what will be done with this power that's set out in Part 24? Thank you for your question. I'm going to answer in English.
May, just quickly to go back to your earlier question with respect to publicly available information. And important to highlight, while 24.1 deals with publicly available information, 25B also does, where it says that we must have measures in place to protect the privacy of Canadians and of persons in Canada with respect to the use of publicly available information. So I think, Mr. Dubé, that goes back a bit to your question before, is what kind of privacy protections would be in place, even if we were to use publicly available information. In particular, the essence on the infrastructure issue. I'm going to turn to my colleague, Dominic Rochon.
Can I just quickly ask, though, on that point, because my time is very, very limited. Those measures protect privacy but don't prevent you from collecting the data to begin with, correct?
It says to protect the privacy of Canadians in the use, analysis, retention, and disclosure of publicly available information.
Sure. So we protect the privacy, but the center can still collect the information based on.
Just jump in
sure.
and try
Go
to
ahead.
answer very quickly, Mr. Dubé. I guess at the essence of why we need this information. As you can appreciate, the global information infrastructure, the internet, it's incredibly complex. We are prohibited from targeting Canadians when we're conducting our activities, particularly when it comes to collecting foreign signals intelligence. So we need to understand exactly how the global information infrastructure is actually set up. Now, there's a lot of public information that's available that explains the infrastructure. So what this provision allows us to do is to study that, understand advances in technology. There are studies out there that are public in nature that allow us then to further to ensure that we're actually protecting the privacy of Canadians, because we're ensuring that we're targeting foreigners outside of Canada when we conduct our activities.
And unfortunately, we're going to have to leave it there. On behalf of the committee, I wanted to thank each and every one of you yes, as we launch into this study. I'm sure there will be other questions, and I'm have some confidence that you might be available for further questions that the minister or the members may wish to ask. So again, thank you on behalf of the committee. Meeting's adjourned.